Mr. Thomas Lubanga Dyilo was found guilty on 14th March 2012 of conscripting and enlisting children under the age of 15 and using them to participate in hostilities in the Ituri region in the Democratic Republic of Congo from 1st September 2002 to 13th August 2003.
Mr. Thomas Lubanga, in a common plan with others, systematically recruited children under the age of 15 as soldiers in his political military movement known as the UPC, FPLC, and used them in hostilities. It is their courage.
The presiding judge, Adrian Fulford, delivered a summary of the trial chamber's decision during an open hearing held at the Hague-based court. He explained that the chamber considered the gravity of the crimes in the circumstances of this case with regard to the extent of damage caused and in particular the harm caused to the victims and their families, the nature of the unlawful behavior and the means employed to execute the crimes, the degree of participation of the convicted person, the circumstances of manner, the age and education, social and economic condition of the convicted person. He highlighted that the crimes for which Mr. Lubanga have been convicted are undoubtedly very serious crimes that affect the international community as a whole. The presiding judge added that the vulnerability of children means that they need to be afforded particular protection that does not apply to the general population as recognized in various international treaties. Judge Fulford indicated that the chamber has, however, reflected on certain factors involving Mr. Lubanga, namely his notable cooperation with the court and his respectful attitude throughout the proceedings.
The defence argues that the detention of Mr. Lubanga in the DRC was imposed as a result of the same conduct underlying the crimes for which he has been convicted at the court, namely his activities as president of the UPC-RP in 2002 to 2003. In the judgment of the chamber, there is insufficient evidence that Mr. Lubanga was detained in the DRC for conduct underlying the crimes for which he was convicted at the court. This contention has not been established on the balance of probabilities, and as a result, the chamber declines to deduct this period of time from Mr. Lubanga's sentence.
The prosecution wanted the court to give Lubanga a sentence to over 30 years in jail. Both Lubanga and the prosecution have 30 days to appeal.
In accordance with the majority decision, Mr. Lubanga is sentenced to a total period of 14 years imprisonment, from which the time commencing with his surrender to the court on the 16th of March 2006 is to be deducted.
Lubanga's case has definitely sent traumas in Kenya. It comes just one day after Trial Chamber 5 of the International Criminal Court issued scheduling orders setting the date for the commencement of the trials in the two Kenyan cases. The case of Eldoret North Member of Parliament William Ruto and radio journalist Joshua Arap Sang will commence on 10th April 2013, and that of Francis Mudhaura and Uhuru Kenyatta is scheduled to commence a day after. Although the dates favored the wishes of the three of the suspects and the prosecutor, all of whom wanted a March of 2013 date, the suspect could be sent back to the drawing board on their defense given the outcome of Lubanga's case. Could the Kenyan case go down on record as the second in which the ICC is handling a jail term to the suspects? Only time will tell. Antonin Anyango, GBS News.